No. Businesses often incorporate themselves because of the benefit of the corporate veil, which means that directors are not personally liable for the debts of the business. Just because the company is going into liquidation doesn't mean that directors suddenly become personally liable for supplier debts. That said, there are circumstances where there can be personal liability, not necessarily for the company that's going into liquidation, but a subsequent incorporated business. Examples are the prohibited names legislation, referred to as 216 claims. If you are a director of a company that's gone into liquidation and a subsequent company uses the same or a similar name, you can be personally liable for the debts of the new company. Also, if you breach a disqualification order, director disqualification order, you can also be personally liable for the debts of the company of which you're a director in breach. So, in short, if your company's going into liquidation, you're not personally liable for the supplier debts of that company, although subsequent conduct could render you being personally liable in a new company. Not necessarily. A director's disqualification order means that you'll be disqualified as acting as a director of a subsequent business for a period of up to 15 years. However, if as a director, if you breach the terms of the disqualification order, then that can lead to criminal liability, either a fine or imprisonment of between 6 to 2 months. But because of the proceedings themselves, you won't necessarily go to prison. It's all online now. Well, that's relatively easy. You complete the online questionnaire. You may have to face an interview before a decision is made as to whether to make yourself bankrupt. I would just say that there are a number of alternative options to bankruptcy which should always be investigated, because bankruptcy is a very severe and significant process for anyone. Examples of other processes available include individual voluntary arrangements, which is basically a contractual arrangement with your creditors to stave off bankruptcy on condition that you contribute assets or payments to a supervisor who will then share that out with your creditors. There's debt relief orders, which operate similar to bankruptcy in a way, in that they last for 12 months, and after that 12 months period you're no longer liable for your debts, but that procedure is only open for any debtor who has less than £30,000 and has no valuables or available income to pay off their debts. There's also the respite scheme, more commonly known as breathing space, which gives any person 60 days to fend off creditor claims, i.e. allows breathing space. There's also an ability to get an even longer break for anyone who's suffering from a mental health condition. The respite process has to go through an FCA regulated manager, but yes, as I say, there are a number of options open to anyone who believes they're insolvent and wants to manage their debt. Well, there's several, and it all depends on the financial circumstances of the business in question, obviously. Three main areas, I would say: liquidation, which is either compulsory if the court makes a winding up order. That's usually obviously a creditor-led process. Voluntary liquidation, where the company effectively decides to put itself into liquidation, which is more of a director-led process. Liquidation is the death of a business. It's a recognition that it's unable to trade. It basically involves a review and a break-up sale of any available assets. The second major type of process is administration, which is different to liquidation in that normally there's a prospect of a potential rescue of the business, or certainly an attempt to preserve the goodwill of the business to achieve better realisation than you would in a liquidation. And the third major process is a company voluntary arrangement, which, similar to an individual voluntary arrangement, involves a company entering into a contract with its creditors to make a contribution of its assets or monthly payments to a supervisor who will then hope to achieve a dividend to those creditors. So that's sort of a very basic overview of the different methods, different processes available to companies in insolvency. Well, they can be significant. Personal liability for a company director derives from quite a basic principle that directors, when they are managing a business that is solvent, owe their duties to the shareholders of that company. However, the minute the company becomes insolvent, then that duty effectively shifts to acting in the best interests of the company's creditors. So at any time directors believe that the company is insolvent and they take advice and determine that the company can't rescue the position, then they have to be extremely careful in how they manage the company's financial affairs. Basically, once an insolvency practitioner is appointed in respect to the company, there will be a detailed review of all the transactions that the business has undertaken for a number of years prior to the liquidation. And basically any payment that doesn't appear to be of benefit to the company, particularly payments made to the directors personally, will be subject to investigation and may be recoverable from the directors under a variety of claims available to the insolvency practitioner. You may have heard of some of them, transactions as an undervalue, so if there's any gifts that the company makes to any third parties, including directors, any creditors who have been preferred, if the directors have been preferred, they've had their loan accounts paid off ahead of other creditors, that could be recovered, and misfeasance for breach of those duties I mentioned at the outset. So yeah, in simple terms, insolvency is a very serious matter for directors, and so it's absolutely crucial that any director of a company that believes that the business is insolvent and is unlikely to be capable of being rescued should take insolvency advice at the earliest opportunity and be careful how the company's financial affairs are managed.